Getting a divorce in Virginia is actually simpler than you might think. One of the spouses must be a resident of Virginia for at least 6 months before filing for divorce. The divorce may be filed in the county or city in which the spouses last lived together, or, at the option of the plaintiff, the county or city where the defendant resides if the defendant is a resident of Virginia, or, if the defendant is a non-resident of Virginia, the county or city where the plaintiff resides. Once the residency requirement is completed, a legal grounds for a divorce must be established. Both general and no-fault divorce are acceptable grounds for divorce. No-fault reasons include living separate and apart without cohabitation for 1 year, or living separate and apart without cohabitation for 6 months if there are no minor children and the spouses have entered into a separation agreement. The reasons for general divorce are adultery, including homosexual acts, abandonment, conviction of a felony and imprisonment for 1 year, cruelty, and willful desertion. Virginia does not require a parenting plan for child custody. Joint or sole custody is awarded based on the child's welfare and considering the age of the child's preference, the needs of the child, the love and affection existing between the child and each parent, the mental and physical health of all individuals involved, the material needs of the child, the role each parent has played in the care of the child, and any other factors necessary for the best interests of the child. No preference is to be given to either parent. Official child support guidelines are in the statute, which are presumed correct unless there is a showing that the amount is unjust or inappropriate given the circumstances. Child support may be ordered upon either parent and is based on the financial resources of the child, the standard of living the child would have enjoyed if the marriage had not been dissolved, the physical and emotional conditions and educational needs of the child, the earning capacity of each parent, the age and health of the child, the division of marital property, the monetary or non-monetary contributions of the parents to the family's well-being, the education of the parents, the ability of the parents to secure education and training, the income tax consequences of child support, any special medical, dental, or child care expenses, the obligations, needs, and financial resources of the parents, support provided for other children or family members, custody arrangements, voluntary unemployment or underemployment unless it is the custodial parent and the child is not in school, child care services are not available, and the cost of child care services are not included in the computations for child support. Debts incurred during the marriage for the benefit of the child, debts incurred for the purpose of producing income, direct court-ordered payments for health insurance or educational expenses of the child, and any extraordinary capital gains, such as gains from the sale of the marital home. Virginia is an equitable distribution state. The separate property of each spouse consists of property acquired before the marriage, any gifts and inheritances, any increase in the value of separate property unless marital property or significant personal efforts contributed to such increases, and any property acquired in exchange for separate property will be retained by the spouse who owns it. The marital property consists of all property acquired during the marriage that is not separate property, all property titled in the names of both spouses, whether as joint tenants or tenants by the entireties, income from or increase in value of separate property during the marriage if the income or increase arose from significant personal efforts. Any separate property which is commingled with marital property and cannot be clearly traced will be divided equitably by the court. The court may also order a payment from one spouse's retirement benefits, profit-sharing benefits, personal injury award, or workers' compensation award to the other spouse. This depends on the contribution of each spouse to the acquisition, care, and maintenance of the marital property, the liquid or non-liquid character of the property, the length of the marriage, the age and health of the spouses, the tax consequences, any debts and liabilities of the spouses, the basis for such debts and liabilities, and the property which serves as security for such debts and liabilities, how and by whom the property was acquired, the circumstances that contributed to the divorce, the contributions, monetary and non-monetary, of each spouse to the well-being of the family, and any other factor necessary to do equity and justice between the spouses. Either spouse may be awarded maintenance, paid in a lump sum, periodic payments, or both, determined by the opportunity, ability, and time necessary to acquire sufficient education and training to enable the spouse to find appropriate employment and that spouse's future earning capacity, the standard of living established during the marriage, the duration of the marriage, the financial resources of the spouses, including marital property apportioned to such spouse, the contribution of each spouse to the marriage, including services rendered in homemaking, childcare, education, and career building of the other spouse, the tax consequences to each spouse, the age of the spouses, the physical and emotional conditions of the spouses, the educational level of each spouse at the time of the marriage and at the time the action for support is commenced, the property of the spouses, the circumstances which contributed to the divorce, the extent to which the age, condition, or circumstances of any child of the spouses makes it appropriate that the custodial spouse not seek outside employment, any income from pension, profit sharing, or retirement plans, any contributions by either spouse to the well-being of the family, the earning capacity of the spouses, including the skills, education, and training of the spouses and their employment opportunities, any decisions made during the marriage regarding employment, career, education, and parenting that affected a spouse's earning potential, including the length of time absent from the job market, and any other factor the court deems just and equitable. However, permanent maintenance will not be awarded to a spouse at fault in a divorce granted on adultery unless to do so would be unjust. Virginia has no legal provisions for divorce mediation. Visit us today at www.mydivorcepapers.com and click on Virginia at the bottom of the page. Let mydivorcepapers.com help you file for divorce today.